I ask unanimous consent to revise and extend my remarks.
Without objection.
Thank you, Madam Speaker. I thank my chairman and friend for yielding. We very often hear people say in this House that they oppose discrimination. Well, today there's a chance to do something more than just say that you oppose discrimination. You can vote against it. I listened to the questions raised by my friend from California, the ranking member of the full committee, and I'd like to address them. My friend says that there are burdensome new mandates imposed by this bill. That is not the case. If an employer has 15 or fewer employees, they're not covered by it at all. And there's really nothing burdensome about the idea that you can't refuse to hire or fire or mistreat someone because of their sexual orientation. That's no more of a burden than having the same rules based on race or religion or nationality. My friend says there are highly subjective measures, and he points to the use of the word perceived discrimination. He says that when we ban discrimination based on perception of sexual orientation, it creates too much confusion. The reality is that precisely the same legal concept has been part of our federal law since 1991 under the Americans with Disabilities Act, or actually prior to 1989 under the Americans with Disabilities Act. Listen to this. I know the word perceived is not in the ADA, but the legal concept is the same. One federal judge in New York heard a case, and that judge says that the case was based on harassment and discrimination based on her perceived disability. I'm not sure this judge is qualified, but most of the Senate does, because it was Judge Michael Mukasey, who's now the President's nominee to be Attorney General of the United States. This doesn't create new confusion. It simply restates an existing principle. On free exercise of religion, the gentleman from California is correct. There was some debate about the proper scope of the free exercise provisions in the underlying bill. Mr. Miller's amendment, which we'll hear shortly, imports precisely the same standard that has existed for the exercise of religion for the last 42 years under Title VII. The gentleman raises questions about marriage and says this is a radical attempt or first step in a radical attempt to redefine marriage. Mr. Miller's amendment will make it precisely true that precisely the opposite is true. Mr. Miller's amendment will take the language that was approved by the House, signed by President Clinton in the Defense of Marriage Act, which defines for federal law purposes marriage as one man and one woman, and import it into this bill. Finally, the gentleman says this is a sweeping departure from civil rights laws. Nothing could be further from the truth. This is not a departure from civil rights laws. It's an inclusion of millions of Americans who should have been included for a very long time. It's a question of simple fairness. It's a question that says if you're a computer programmer or a bus driver or a carpenter, your job situation should be based upon how well you drive the bus or how well you program the computer, not on your sexual orientation.
I yield back. Gentleman from